Thank you very much, Andrzej. Good morning, everybody. It is my great pleasure and honor to be here. Thank you very much for this invitation. I will address this very specific issue of how much flexibility the new public procurement directives actually bring to the system. And the very short answer is a lot. Before I develop this, and before I even convince you, I would like to present an overall context, the scope of the reform, and its objectives. As you can see on the slide, we have entirely new three public procurement directives. Directive 2014-24, which replaces the current classic directive, and Directive 2014-25, which replaces the current Utilities Directive. We also have an entirely new directive, Concessions Directive 2004-23, which is a great achievement because, as you all know, concessions for the time being are not regulated by EU secondary legislation, with the exception of works concessions and a very limited body of rules concerning works concessions. So we have this entirely new directive. There were other parallel initiatives accompanying the reform. International procurement instrument, which is a regulation proposed by the Commission aiming at opening up public procurement markets worldwide to EU companies, and Directive 2014-55 on electronic invoicing in public procurement. Its aim is to overcome the existing disparities on invoicing in public procurement in Europe. All three directives, public procurement directives, the core order of the reform, they are already in force. They entered into force in April 2014. Member states have 2 years to transpose them. The UK, as we have heard, is very advanced in this transposition effort and has already transposed the classic directive, which we welcome. So this is the state of the law. This is what the reform brings. As to the objectives, as you can see, one of the most important things was strategic use of public procurement. How to improve the legal framework, the existing framework, to take into account social aspects, environmental aspects, innovation-related aspects. There was also this need to introduce a stronger measure to prevent favoritism, conflict of interest, and corruption in public procurement. The legislator also intended to introduce specific measures aiming at improving SMEs' access to public procurement markets, and better governance objective aimed at improving enforcement of the rules through increased monitoring measures at the national level. Finally, I left this for the end. First and the most important objective of the reform was to create a much more flexible legal framework. And now we're going to see how this objective was achieved. As you can see, what the directive brings, and this is the biggest achievement, I would say, in terms of flexibility, is the fact that it allows for more negotiations in public procurement. You know very well that the current rules have been quite heavily criticized for being too rigid. One of the most criticized features was the ban on negotiations, which exists in the open and restricted procedures. At the same time, the use of negotiated procedure with prior publication was confined to very specific circumstances which were interpreted quite restrictively in the jurisprudence of the Court of Justice. And this criticism was taken into account in the reform. The EU legislator recognized expressly, as you can see in one of the recitals, that contracting authorities must be given flexibility to choose a procedure which provides for negotiations. The legislator did not, of course, remove ban on negotiations in open and restricted procedures. Instead, this flexibility was achieved through enlarging the scope of a flexible procurement procedures, competitive procedure with negotiation and competitive dialogue. So those two flexible procedures become more generalized in the reform. They do not become general as open and restricted procedure, because there are still some conditions to be able to use these procedures, but these conditions are also rather flexible. Like, for example, the contracting authority will be able to use these procedures when the contract includes design or innovation, when there is necessity, it is not possible to achieve the objectives of the contracting authority through adaptation of readily available solutions. So these procedures will not be able to use, will not be able to be used to buy off-the-shelf services or supplies. The flexibility was also achieved through the creation of an entirely new procedure, innovative partnership for innovative products. This is a procedure that will allow the contracting authority to combine both research and development phase with supply of the product which will be developed. Another achievement is quite considerable reduction of documentation requirements in the new directives. As you know, many economic operators, not only SMEs, complain quite often about documentary requirements, that they have to produce endless certificates in the context of public procurement procedures, not even being sure that they will be awarded a contract. So this burden was in many cases disproportionate. This was also taken into account in the context of the reform, and this is why the European legislator created something which is called the European Single Procurement Document. This is nothing but an updated self-declaration that the economic operator fulfills the conditions of participation and is not in the situation of an exclusion. So the contracting authority in general will not require all documents. It will be sufficient to provide the contracting authority with the European Single Procurement Document, and only the winning bidder later on will be asked to provide full documentary evidence that it fulfills the criteria and is not in the situation of exclusion. This is a document that can be reused in the context of procedure, and it should bring much more flexibility for both economic operators and contracting authorities. Just for your information, this document will be based on a standard form, and currently the Commission is working on the implementing regulation that will introduce this standard form. Another important thing from the perspective of flexibility is quite a considerable reduction of minimum time limits. As you can see, they were reduced by 30% in the directives. For open procedures, time for submission of tenders is now 35 days. It used to be 52 days, so you can see that it is quite important, this reduction. For restricted procedures, time was reduced from 40 to 30 days. Time for the receipt of tenders, because time for requests for participants does not change, and it is still 30 days. As you can also see, further timescale reductions are possible in the case of urgency. This is something that already exists in the current legal framework, but for the very first time, the contracting authorities will be able to reduce time for open procedures in the case of urgency from 35 to 15 days. So it is also a considerable reduction. The legislation also specifies what this urgency is, and it says that it will not be necessary for the contracting authority to prove that this urgency is brought by unforeseen circumstances not attributable to the contracting authority. So this is something less than is required for the negotiated procedure without a prior publication. There will be even more flexibility for subcentral authorities. Here you also know very well that these subcentral authorities, small authorities, municipalities, regional authorities, local authorities also complained about the fact that the application of the full regime is not maybe the best option in their case, and sometimes it's also disproportionate, requires too much time and effort. This criticism was also taken into account in the context of the reform. The legislator decided to use some flexibilities which exist under the GPA and decided to allow member states to allow certain subcentral authorities to advertise their contracts through prior information notice and not through a contract a contract notice. So instead of publishing an EU-wide contract notice, these subcentral authorities will be able to publish PIN in which they will invite interested economic operators to express their interest and in which they will say that no further publication will be provided. The use of PIN will be restricted only to restricted procedures and competitive procedure with negotiations. However, it brings much more flexibility for local subcentral contracting authorities. For restricted procedures, these specific authorities will also be able to agree on time limits with economic operators. Provided, of course, that all selected candidates will have the same time to prepare and submit their tenders. Another important thing is light regime for certain services. The directive actually changes the scope of changes the existing coverage of service contracts, public service contracts. Because as you know, right now we have A and B services. A require the application of the full set of rules, whereas B require an application of a very, very limited set of rules. So the legislator decided to get rid of this distinction. And the option was that all services would be subject to the full set of rules, but of course it turned out that some services are still of a very limited cross-border interests, and there is no need to treat them in the way other services are treated. So the legislator decided to create a special regime for such services. What we mean by these services are social services, cultural services, educational services, services which are really of very limited cross-border interests. They are all mentioned in Annex 14 of the directive. Here we will have a higher threshold which will trigger the application of certain rules. It will be 750,000 euros, and only there will be ex ante and ex post transparency requirement, general principles of EU law, and for the rest, national procedures will apply. There is also more flexibility for contract award criteria. You know very well that the new directives favor more quality in public procurement. They allow to take into account environmental, social, or innovation-related considerations. And to achieve this aim, the notion of link with the subject matter of the contract was relaxed a little bit, because when we talk now under the new directives about the link to the subject matter of the contract, we mean any link, any connection to any stage of the life cycle or a connection in any respect. It does not have to be a connection to a material substance of the product. So as you see, this relaxation allows to take into account innovation-related criteria, social criteria, and environmental criteria to a larger extent than it is possible now. There is also one important reform, modernization, or improvement. Now, under the current directives, it will be possible to take into account organization, qualification, and experience of staff assigned to performing the contract. where the quality of the staff impacts significantly on the level of performance. So this is an important clarification brought after the Yanakis jurisprudence. In-house is another important theme. To a large extent, as you know, the new directives codify the court's jurisprudence on in-house with some additional elements that bring this additional flexibility to the rules. As you know, the Court of Justice has been very strict on private participation in in-house setup. Private participation was excluded, never allowed. Now the rules provide that indirect private participation in the controlled legal entity will be possible. And direct private participation in the controlled legal entity will be possible provided that it is a non-controlling and non-blocking form of private capital participation required by national law. So this private participation is confined to certain specific circumstances, but still it is a major opening compared to the current state of law and compared to the court's jurisprudence. It was also specified that the controlled legal person has to carry out more than 80% of its activities in the performance of tasks entrusted to it by the controlled contracting authority. In the proposal of the directive, the Commission proposed actually 90% threshold, but in the course of negotiations, this threshold was lowered down even more. Finally, the directive clarifies that in-house exemption applies to sister companies and reverse in-house situations. So there is much clarity. We have some jurisprudence coming from the Court of Justice on this, but for the time being it has been made clear, and it is a major clarification in the reform. There will be also more flexibility for contract modifications. Here, the legislator, the new directives also to some extent codified the existing jurisprudence, relevant jurisprudence of the Court of Justice, but they also add some additional elements which bring more flexibility. As you can see, for the very first time, the legislator decided to provide the minimis rule or safe harbor for minor modifications. So it will be the contracting authorities will be able to modify a contract without a new contract awarding procedure, provided that this modification, the value of this modification, is below both the relevant EU threshold and 10% of the initial contract value for services and supplies, and 15% in case of works. In its original proposal, the Commission actually proposed 5%, and as you can see, some additional flexibility was brought in the course of negotiations by bringing these thresholds up. Then, if you compare two provisions of the current and the new directives on additional works, services and supplies, and modifications brought about by unforeseen circumstances, you will realize that there is much more flexibility under the new rules. Just to give you an example, under the current rules, for additional works and services, it is not possible to take into account economic considerations, whereas under the new rules, it will be possible to take into account economic considerations. It is also specified that any increase in price shall not exceed 50% of the value of the original contract. Under the new rules, this 50% relates to consecutive modifications, whereas under the current rules, this 50% threshold relates to cumulative aggregate value. So it is also an important modification. There is this caveat in the directive that such modifications cannot be aimed at circumventing the rules, but still you can see that there is much more flexibility for additional works, services and supplies, and for modifications brought about by unforeseen circumstances. And there will be even more flexibility for concessions compared to public procurement. Of course, everything is relative, and some might say that now we have the treaty principles, at least for service concessions, and now we have the new directive, so where is this flexibility when we have new rules? But from the very beginning, the intention of the Commission was to provide clarity, legal certainty for concession contracts, and at the same time to achieve flexibility for such contracts, to take into account their specific features, that they are long-term, complex, that the contractor often bears risks which are normally borne by the public sector. And for this reason, the intention was not to go beyond this what is strictly necessary under the treaty principles and not to over-regulate. And we think that to a large extent this objective was achieved. Just to give you an example, for concessions, there are no concession award procedures provided in the directives. So member states have flexibility here on how to implement this provision, whether they want to create specific provisions on procedures or whether they want to leave more leeway to their contracting authorities. Negotiations will always be possible, provided that, of course, there are some safeguards in the procedure that guarantee equal treatment and transparency of the procedures. There is also more flexibility for contract award criteria and selection criteria. Contract award criteria, the rules on contract award criteria in concessions are much slimmer when you compare to the Public Procurement Directive. And selection and exclusion criteria to some extent mirror this what is provided in the Public Procurement Directive, but there is much more flexibility in terms of means of proof and evidence which is required from economic operators. So this is where you are. I just gave you some examples, probably the most obvious of flexibility under the new directives, but if you read the directive, then you will realize that there are many more elements that are flexible. And one has to remember that the directive is a result of a compromise. So for some, those provisions went too far, for others not far enough. But we think that this initial objective of the legislator to provide for flexibility was achieved, and it is now for the contracting authorities to use the new rules. Thank you very much